We both get in.
We're live. Hi, everybody. So welcome to our usual tradition of Therapy Tech with Rob and Roy, wherein Rob and Roy wrestle with Google for about 15 minutes before we start the show. This seems to be kind of how our show goes. Right. How you doing, Rob?
I'm doing great, Roy.
I can tell you're very excited right now. Okay, so today the what we have this time is we have Nancy Wheeler, who is we're really happy to have her on the show. She is a risk management consultant for the American Counseling Association. She co-wrote a book on private practice emergency preparedness with Rob. The problem we have is Google doesn't seem to want to let her join this hangout, or Google is confused about how she can join us. So she is on Rob's telephone, and I think honestly, Rob, this is a great example of how we don't always want to rely on technology. We need to have backup plans for emergencies and things like that. What do you guys think, or what do you think, Rob?
I think that's probably a good idea. She's right on my phone. We've shrunk her down.
Oh, nice.
Right there on my phone. So, how you doing, Nancy?
I'm doing well. The technology is great when it works.
Hey, the technology you're using right now is working well. We can rely on it as a backup.
Right. Yeah, I guess that is our point. We always have to have contingency plans, don't we?
Exactly, we do. Too bad we didn't think of this particular one ahead of time.
Yeah.
Right. So Rob, if I try to talk directly to Nancy, it doesn't work as well as when Rob talks to Nancy. So Rob, can you ask Nancy to introduce herself and to tell us a little bit about what she's going to do on our show today?
Did you catch that, Nancy?
Yeah, I think you asked for a brief introduction. I am an attorney, a healthcare attorney in private practice, and I've had the privilege of working with the American Counseling Association for several decades. I've also worked extensively with psychiatrists and other mental health professionals. And one of the things that I've been concerned about for a number of years really arose out of experience I have with the psychiatrists I deal with. I've had a number who have unfortunately died suddenly, heart attack, accident, whatever. And then they leave a grieving spouse or significant other with the task of, oh my gosh, what do we do with these patients, these clients? What happens? What do we do with the records? And oftentimes these are people who are not other mental health professionals who are grieving and then stuck with the task of trying to do something. And then there's a secondary issue, and that is, how do you prepare for ultimate retirement? And maybe because I'm getting a little closer to that stage than the two of you are, that's become something I'm interested in myself. How do I prepare, not just financially, but anybody who is a professional, and especially in private practice, what are we doing to ethically and legally leave our practices and our clients in a good place?
Got it. Okay, so I know here in Oregon, let me just sort of kind of revamp what you just said. So you're talking about needing to prepare for if something happens to us and we're suddenly left with a spouse or partner or other who has to deal with how to deal with the aftermath involving our clients or patients, or just preparing for retirement, which is not as simple as just stopping. You don't just stop. You have to do something with that, right? So that's here in Oregon. We recently the Counseling Licensing Board recently added a legal requirement that we have someone on record with the licensing board who is our backup, the person who can work with our clients if we disappear or become disabled. This is the kind of thing you're talking about, right?
It really is the kind of thing we're talking about, and I think we're going to see more regulations popping up in various states, precisely the type of thing you're mentioning in Oregon. The American Counseling Association's Code of Ethics now requires counselors in most settings, private practice settings, to have a records custodian. And I just think as we are seeing more and more baby boomers getting to the point of, something is happening, they're retiring, and this problem is cropping up. I think we're just going to see more and more of this kind of regulation.
Got it. Right. So it's not just ethical; it's also becoming regulatory.
Mm-hmm. Yeah.
Okay. So what? So I know you and Rob authored a book on this subject, and it has a lot of advice and forms and things of that nature. Of course, this is the Therapy Tech Show. Is there some relationship between these regulations or ethics codes and the technology we're using?
This is Nancy, and I'm not sure whether that was addressed to Rob or to me. Let me give you my 2 cents, and then maybe Rob, you could fill in the blanks, and you've got more of the tech background. But one of my concerns, being a healthcare attorney, is that a lot of mental health professionals are not up to speed on HIPAA and high tech. And there's now an obligation to report breaches, to notify clients and the federal government of breaches of information. And if the professionals don't take care of this now, you compound this issue with they're not making provisions for what happens if they die or become disabled. There could be breaches, and it could lead to big fines, and this really could become a big problem.
Can you explain what you mean by a breach? Like, give an example. It doesn't have to be a technology-related example. Any example of what you mean by breach in this case?
Well, I'll give you an example through the risk management program through ACA. I got a call from a counselor last week who had a house broken into, and this was actually paper files that were in a satchel that were stolen. But for counselors who are covered under HIPAA, and that's a great number of counselors, even the paper records are subject to these regulations. I've had other situations where somebody lost an unprotected laptop or an unprotected iPhone, and there was protected health information, client information on those devices. So the interface between technology and this issue of planning for either retirement or sudden closure of a practice is all interrelated. And then there's another issue in terms of, after something happens to the professional, who has the right to access those records? And you've got the issue that they have paper form or they elect an electronic form. How does the records custodian or like you in Oregon, if you have to have someone on record to take care of this, you've got to have a way for them to access the information that was on your computer. And this should probably be put into an informed consent document so clients know that. Rob, do you have some follow-up on that?
Yeah, and we're kind of wrapping around in circles. You get to the informed consent and making sure that not only your clients are aware, but making sure that your emergency response team, the people that will have to take over your practice in the event of any kind of emergency, is also aware of all the systems that you're using. That kind of wraps us back to the technology part, with so many people moving to electronic health records. There's already a learning curve for us as we learn new systems, but then if you have somebody coming in an emergency needing to know how do they access your records and get to phone numbers so that they can notify those that they need to notify, and making sure that that is documented so that there's not a delay.
And so it's interesting. I didn't think about this myself. So you're saying, and it makes a lot of sense. Your informed consent for new clients needs to let them know that there may be another professional who accesses their records in the case of one of these emergencies. Is that right?
Exactly.
Yeah, that sounds like an important piece that a lot of people may not think about. Because personally, I know I'm going to be thinking more about the logistics of how that person gets into my stuff, which also is very complicated. I'm not necessarily thinking about how I need to make sure my clients know that this is another person who would, and they're not even doing unauthorized access. They're doing authorized access. This is another person who is authorized to access that client's record. That seems an important thing for clients to know about up front.
Well, and it's good for them to know about it, and it's also good, for them to know you have a plan for emergencies, to know that they're going to have continuity of care
Right.
in case of something coming up.
Right, right. So this is a $10,000 question for Nancy. Now this is a question I got a lot after the Oregon Counseling Board passed this new rule. A lot of people were asking me, well, if I do have an emergency and my custodian of record then takes over my records and starts contacting clients and trying to take care of their situation, what if my custodian of record does something that would violate HIPAA or other state laws or even ethics codes? Where does the liability lie?
Well, and I think the answer to that is you would probably need to execute a HIPAA business associate contract with anybody who would have access to those records. I think if I were a professional and I were choosing somebody to serve as my records custodian or backup person, I would want to choose somebody who already was a HIPAA-covered entity that would know something about it. I want to talk with that person to make sure they understand how they're keeping records right now, that they're aware of it, that they comply with HIPAA, that they have policies and procedures, and they employ the notice of privacy practices and all that. And it might be one of these things where you could have a group of similarly licensed professionals who agree to act as backup for each other, and then occasionally you may have to add somebody to that group. But unfortunately, if somebody's life is lost or they become disabled, it might be time then to add another person to that group, so that you're really acting in a collegial manner to back each other up. But
That's a good idea.
of that HIPAA business associate contract, you can deal with where the liability would fall with that. But I think that would be your responsibility to make sure that it's somebody who knows what they're doing. I get so concerned with mental health professionals who are just using their spouse to handle this. The spouse may be the personal representative of the estate from a legal standpoint, but what if that person is an interior decorator? What do they know about HIPAA responsibilities? Nothing.
Right.
And unfortunately, for years, doctors and mental health providers would often just have a spouse handle this kind of thing. And I think it puts the spouse in an awkward position at a time when they could be grieving, but worse than that, it could compromise the privacy of the patients and clients that we're talking about here.
I think it's worth adding to that too. From a risk analysis perspective, purely, another difficulty of having a domestic partner or a spouse be the person who takes care of your records is a lot of the situations in which you might end up being disabled or lose access, such as getting lost on a trip, getting injured while away from home. There's a decent chance your spouse or partner would be with you. So if you're relying on the spouse or partner to be the person who takes care of the records, there's an increased risk that that person will also be disabled or lost if you are disabled or lost. So it seems like that's another reason why relying on that partner is not necessarily the best plan. Yeah, that was sort of my thought there. That's going back to my risk analysis brain.
And Rob, I may let you respond to that because I heard some of it, but not all of it.
Yeah, Roy was talking about, a lot of the reasons that you'd want to avoid having a loved one or, significant other or a family member handling all of those details. And certainly there's the fact that they're going to be busy dealing with many other things, but also the technology component. They're not going to be somebody who's likely well-versed in HIPAA and what it means to be a business associate and be able to maintain the privacy and confidentiality of records.
Right. No, I agree 100%. I also think that it's important to work with one's personal attorney at the time you are creating your own personal will, and at the time you may be thinking about advanced directives and those types of things. I have occasionally worked with trust and estate attorneys who really don't know anything about the ethics of this, and I've had some consultations with that type of an attorney in terms of setting up the right way of dealing with all of lot of times people's personal attorneys are handling wills in the state may not be aware of the concept too of having a professional will that kind of directs what happens with things of the practice. And so I think we need to dialogue, and I think the profession needs to dialogue about ways to handle all of this and to try to integrate some of the personal and the professional. And obviously, if somebody does pass away, the executor or personal representative of the estate should be involved with this process, but should be involved with the records custodian or the emergency response team.
Okay, that makes sense. So that actually brings me to the next question. We're talking a lot here about responsibilities and potential issues. I'm sure a number of the viewers right now are thinking about practical things. That tends to what comes into our heads when we talk about responsibilities. So I would love for Nancy to talk about the practical issues of what are the ethics and what are the ethics and what do the typical laws say we're supposed to do to prepare? And then how does that translate to practical preparedness? And then we'll probably have Rob talk about how you can kind of configure your technology to take care of those responsibilities. So can we have Nancy respond to that, the idea of what are the practical requirements or practical things that we should do?
Yeah, it's interesting, Roy, because there is a dearth of information on the legal front in terms of what professionals should do. I mean, the Oregon regulation that you mentioned, those things are few and far between. That's why I'm saying I think that we're going to lead to that point. But I've even looked at a number of, sometimes you look at something for physicians, the Medical Practice Act, for Counselor Practice Act. Some of them, like counselors, may have an obligation to appoint a records custodian, but it doesn't go into too much detail. Some of the laws on the books for physicians are just, they're really old and outdated. And I think that one thing, for example, and this is something we've given a template with in the book, the e-book that Rob and I have collaborated on, that's called Private Practice Preparedness, and it's at privatepracticepreparedness.com. We have incorporated a template of a records custodian agreement, so that some of these things are laid out that will address some of those practical things. We also have in there sample notice documents, like templates that can be used so that the records custodian or emergency response team member can appropriately notify clients. And, if this is a sudden death, clients could be very, very upset by the death of a therapist. So we've done it in such a way to try to make sure that there's some flexibility in this process. And the whole reason we've created templates is you can tailor it then to your own circumstance. So that's where we get into the real practical. We also created a practice reference and sort of a step-by-step guide to closing a practice, because it's hard to think of every little thing. So we really tried to brainstorm and come up with all the things that somebody must do and try to put them in an order that makes sense. So that, what's one of the first things that you're going to have to do, that the clients are going to have to be notified. You don't want to wait 3 weeks. People may be calling for appointments. So, we've addressed that. A little later on down the road, you're going to notify other entities like the health insurance companies that you may participate with, different vendors you have, your banks, and all of that. So it can become overwhelming when you first start thinking about it. And I think a lot of mental health professionals push this off, and they kind of act like ostriches because there's a lot of denial about the need to do this. There's always something to be done, but without spending a little bit of time preparing for this thing, you could really be doing a disservice to your client.
Right. So kind of what I'm hearing you say is that, and I actually agree with what you were saying about the law. I just know the one law here in Oregon, and you're correct. It's very simple. The only purpose of the law is actually to make sure that every counselor tells the licensing board who their record custodian is. Like, that's actually the purpose of the law, is just so that if a client suddenly loses you, they can contact the licensing board, and the licensing board can tell the client who they're supposed to get in touch with. That's the entire purpose of the law. And it doesn't tell the counselor what you're supposed to do with your record custodian. It doesn't have anything about making sure the custodian like even has like your file cabinet keys, much less like computer passwords or things like that. And I know the ethics codes are similar.
No, it would be a very difficult thing to have the law or the regulations too detailed with this type of thing. But you have to go beyond that. I mean, I think Oregon has made a really good first step with this, but I think counselors, if they're really, or other mental health professionals, if they're practicing aspirational ethics, they have to realize that they could really harm clients by not thinking this through. And you can't wait until you're 50 or 60 or 70 years old to do this. There's something that happens to somebody who's old and new to a private practice.
I love how you're talking about this, because this is the kind of thing Rob and I are always talking about, which is like it's great if the law or the ethics code tells you exactly what to do, but that's just not practical to reality. Like the ethics code of the law, including HIPAA or now the ACA Code of Ethics, the NASW guidelines, NVCC guidelines, APA's telepsychology guidelines. All of these documents, they'll try to tell you as much guidance as is feasible, but from there you really need to use a lot of professional judgment, and there's a certain amount of expert knowledge that's necessary, which is why people like Rob and I are writing about this stuff. And so I think with this preparing for emergencies, what we're hearing is the ethics codes say you got to do something, you got to prepare, you got to make sure your client's taken care of, and then from there it's up to professionals to figure out what does it actually look like. Like, how do you actually do that? And
I think we have to be reasonable with all of this, too, because if the regulations are so detailed and you have a one-size-fits-all, is somebody who's in an agency or school setting in the same position as somebody who's in a private practice? And I would argue not necessarily, because you might have built-in people who would really be acting as the records custodian in an agency or in certain school settings. Not always. But if you're a solo private practitioner, or in a very small practice, this becomes critically important, I think, to make sure that there is an organized listing of where things are, where to get them, how to deal with clients, contemplating everything that you can write down. I developed one of these for my own. When I went into my own solo law practice, I kind of came up with a kind of step-by-step thing that I gave to somebody that was my backup. My spouse happens to be an attorney too, so he's also included in this. But even things like if they don't have the password to get into wherever you have all of this, they're stuck.
Right.
A terrible situation. I dealt recently with a psychiatrist who passed away. A colleague calls up and says, "You don't even know how to notify patients because we don't have a list." He had a way of dealing with his patients by listing them by initials. We had no idea who these people are. So you could just see the implications of that.
Right.
And I would think most patients or clients would want to know that there's a qualified professional stepping in to handle that.
Right. So what you told us about so far is I mean, an early step, of course, is informing clients that there is a plan. And and that they may end up, something happens to me, there is a professional who's going to contact them. That professional is going to access their records.
You're letting them know that's who it is. And let's say a client says, "Oh my gosh, you're using Rob Reinhardt as your backup." Well, I have history with Rob, and I don't want that. But that person would have the ability either to get somebody else to take over. No offense, Rob. I can't imagine anybody saying
Sure,
that.
Nancy. Sure.
Or they have the option of going to another therapist if they do that. So I think the clients have the right to know who's going to step in.
Okay. Makes sense. So, of course, we want to inform them if our custodian changes.
Yeah. And so there's a need to periodically look at this information so that you make sure everything's up to date.
Right, right. And then of course, on the custodian side, it sounds like you're talking about the need to leave them very detailed instructions on what to do and how to do it, especially, as you're saying, given the way we often kind of encode things, partly for privacy, partly for our own efficiency. Like, because you're right. I mean, I thought about that. Like, except for the actual intake forms, like all my information about my clients is encoded. Like I don't use their full name. I kind of encode it in a way that's easy for me to recognize. But if someone has to take over that stuff, they have no idea what any of it means.
That's exactly right. That was exactly the situation I was dealing with a couple of weeks ago.
Wow. Okay, that sounds rough, and that sounds like a lot of stress for the person who's trying to take over and help you.
But it's not as many steps if you do something proactive and you get everything organized. So all the person has to do is really look at a series of documents. And Rob, do you want to explain a little bit more, like with what your thinking was when we developed this in terms of the interplay between the practice reference, the technology quick reference, the step-by-step guide? Because you had some really good thoughts, I think, in organizing that.
Yeah, our whole goal in creating this book and the templates that come with it, and the templates, the more I speak with people who have purchased the book, the real value is in these templates. And certainly we get into some of these practical details in the book of why do you need to do this and what is the kind of information you want to convey. But the templates help you create this set of documents that you can simply hand over, and the person can step-by-step follow through these this information and take over your practice if they need to. So what happens is, Nancy mentioned, there's the practice reference, and it lets you fill out everything from your MPI number to the insurance companies you deal with to who your bank is, to who your attorney is, everything anybody would ever need to know about your practice. And then that meshes directly with the step-by-step guide to closing a practice, which actually takes you through, like Nancy said, this prioritized list of here's what you need to do. First, you need to make sure you're contacting the clients and letting them know. And it takes you right down the list, and it cross-references to all this data in the practice reference. So it'll say you need to contact clients, and here's where you look in the practice reference to figure out how to contact those clients. And so you go to the practice reference, and it may say, log into the XYZ practice management system with this password and you'll find all the client information, or it may be go to filing cabinet in Office 107 and here's where you get the keys. So you're able to completely customize this based on your practice, and once you've completed it, you can hand this over to somebody and they'll be able to find anything that they need to without going through those, what Nancy has recently encountered.
And Rob, I would add to that, it just kind of addresses Roy's issue from the outset. This is the kind of detail that they can establish based on what we've come up with here that couldn't possibly be in law or regulation. It's just way too detailed to do that. And we're also not trying to say you should never get your own attorney to draft the will or to look at your contracts, but I think what we're providing, if you also work with your own local attorney, it's going to cut a lot of attorney time out of that. So it's probably going to save people a lot of money because they're not going to have to reinvent the entire wheel. And we are also suggesting that people share this. We give a limited license to share the templates and all that with somebody's personal attorney because we realize how important that would be. It depends on what state you're in, because if you're in Oregon, you have certain responsibilities. If you're in Maryland, you may have other responsibilities. So we want this to be user-friendly everywhere, but we're not trying to say you shouldn't use your own attorney to draft your will, your professional will.
Right. Well, and it also sounds like one of the things you guys are trying to develop, which seems kind of important, is I don't want to say like a standard of practice, but something that can at least give people an idea of what a minimum reasonable standard is, right? Because I mean, like you said, the regulation can't define everything, but we as professionals can certainly work together to understand and define what we can expect from each other.
Yeah.
Right on. So Rob, you were talking about a lot of reference lists, right? And they contain things like passwords, especially to really sensitive software like electronic medical record systems, assuming that someone has such a system. How do you keep that secure? And actually, honestly, my risk management brain is really interested in how do you keep that updated? Because I change my passwords every quarter, like a good techie, right?
Right. So again, this is a template. It provides a framework, but it's done in such a way that you can customize it to your own situation. So the first answer to your question is, how do you keep this all secure? Well, there's multiple ways you can do that. You could keep this information with your attorney. Perhaps you have a secure way of communicating this message and updating it with your attorney. Perhaps you have a secure lockbox somewhere that if you update it every 3 months, well, you'd have to go and visit that every 3 months. But there's certainly, you're well aware, there's ways to store this stuff in an encrypted manner or a secure manner so that it's easily accessible by your attorney and anybody else on your emergency response team that would need to get to it.
I like this idea. I want to. This is not. No, sorry. Go ahead, Nancy.
What I mentioned before about informed consent, is you have your clients read that over, talk to you about it, and sign a document, and that recognizes and indicates who these people are, who are your backups. They're really agreeing to that person dealing with this protected health information too. Right.
So I like the idea. I hadn't thought of this. Doesn't occur to me of having the attorney be that contact person who can hold on to the information. Because I mean, attorneys are definitely accustomed to performing that kind of service, right?
Yes, the attorneys may be able to do that, but I think as long as your clients agree, it could even be somebody on the emergency response team that's the repository of that information. If your clients agree to it, they understand who's taking this over.
Yeah, a good analogy is many people, especially those who are dealing with insurance, use a third-party billing company and have a business associate agreement with that billing company and make sure that that's in their informed consent with their clients that, hey, I use this third-party billing company. They do have access to some of your protected health information for purposes of filing insurance claims. And so this is a similar situation. I also have this agreement with people on my emergency response team who can respond in case of an emergency and will have access to your protected health information.
Nice.
Or you have a HIPAA business associate contract with your attorney, so the attorney also agrees to.
Right. So, Nancy, I have a question. So we've talked about business associate contracts. Let me make sure that everyone watching knows what that is. Under the HIPAA law, to speak very broadly about it, if a third party is allowed to create, receive, maintain, or transmit, meaning just handle in general your protected health information, generally speaking, you need to get a business associate agreement with that third party in order to comply with HIPAA. Right? That's a HIPAA rule.
That's generally true. There'd be, some exceptions. For example, if you had somebody on your workforce, that's already been trained in HIPAA procedures or whatever, that person could handle that function without you having to execute a HIPAA business associate contract. And that's why I think it's different. If you have a multi-professional practice, those other people in your practice who have all, if they're all HIPAA-covered entities, they may be able to do it without execution of a HIPAA business associate contract. But again, each one of those situations is going to have to be looked at in particular. And I'm most concerned with those solo private practitioners who are just dealing with an outside entity without getting that protection of having that HIPAA business associate contract.
Right. Yeah, usually kind of outside entity is kind of that watchword for business associate. Like that's generally when you need to be thinking about business associates. But I do know, and just for some viewers' information, there are some states where they can be very particular about the business associate rule. So I mean, it basically goes with what Nancy's saying, is you need to figure out what your local law says, just to be sure.
Right. There are also other states that have created breach notifications that kind of go beyond HIPAA, and there's a state like Texas that has its own kind of version of HIPAA. So that's why you can't just do this in a nutshell without getting some.
Yep. So as we tend to find out is the case, Texas is different from everybody else. Right. And they are. If you're in Texas, you should be aware of that. Like your own version, like your own laws around HIPAA are very different from the federal law. Or at least much tighter. Right. So I did have another question for you, Rob. I mean, so like what do you have any interesting technical advice about how to like how you share passwords with people? I mean, that seems to me like such a sensitive thing.
Again, just like the laws, there's not like one particular way that you can do this. And it may partly depend on who it is that you're sharing the passwords with and how often you communicate with that person. So like we said, one method would be to have one person serve as the hub, like an attorney or a trusted records custodian or someone on your emergency response team. As far as the practical sharing, it could be a matter of, especially if it's multiple passwords, having it on some kind of encrypted drive that person knows the master password to. It could be that some password managers that you use online now include a facility for having a secondary person access it. So you can set up a secondary user who's only allowed to access a limited number of passwords. You can actually segment your passwords into, well, my professional passwords and my personal passwords, and give somebody secondary access to those that you set up in this own little section for, counseling / therapy / emergency use. So there's lots of ways that you can do it securely. One of the things we include in with our templates is a spreadsheet where you can list all the different systems and devices and software that you use, as well as what passwords they have. Obviously, you'd want to secure that document before sharing it with somebody, but it's one other way that you can put everything all in one place.
Got it. Right. That
devices that just rely on thumbprint identification. That just popped into my head as Rob was talking. That would be a problem, wouldn't it?
Can you say that again?
If you had electronic devices that just relied on thumbprint recognition, that could be a problem here, couldn't it?
Yeah,
it's a real problem.
I'm glad you bring that up. There's a couple points behind that. One is that many of the thumbprint devices include some kind of backup. They include some kind of backup password, so that if you aren't able to use the thumbprint, or there's some error in the technology, you have a backup way to get into the system.
Yeah, you need to make sure you have a backup, right?
Right. Another reason that's right, exactly.
I have a thumbprint on my iPhone, and my wife also has her fingers registered on the iPhone. So like you can also have the other person's fingerprints registered on the device.
Right. Yeah. I don't have an iPhone. I've got one of their competitors. But yeah, I think it'll let you put 3 or 4 different thumbprints or fingerprints in there. So you have that backup plus a password backup.
Plus the password, right.
Every time I activate my iPhone, if I turn it off, I have to put the password in.
Right.
And for the rest of the time, I can stick my thumb on it and do it.
Right.
I think, another one of those things to make sure this is fail-safe. Yeah.
Well, another important point this brings up, and we mentioned this in the book, and it's part of the process you go through if you go through filling out our templates and following the instructions that are included, is making sure, again, that these third parties, especially if you're using something like a practice management system or electronic medical record, that you make sure they have some process for somebody else accessing your system. Make sure they know that this other person that now has your password has your permission to access that system. Even make sure that some of them even have a list where you can tell them exactly who it is that is your backup, who has permission to access that data.
I entirely agree with that. It seems to me it's... Oh, sorry, Nancy. Sorry, go ahead, Nancy.
Had a suicidal client who finds out that you, the therapist, just died suddenly, and somebody's got to take that over pretty quickly, and they can get access to any information.
Right.
That should be a real problem.
So what you're addressing there, Nancy, is the need to be able for the emergency response team to be able to do this fast. This can't be a slow process. It needs to be something they can take over at least reasonably quickly.
Yeah. Time is of the essence.
Right.
And, yeah, I want to throw out there that we've talked a lot about the potential of a therapist dying or other emergencies that require this timeliness. But I also want to throw out the caveat that it's really important that people not assume that's the only reason you might use this information in this process. I often run into people who have no plans to retire anytime soon, but life throws a curveball their way. They're provided some job offer they weren't expecting, or someone else in their family gets ill, or there's a death somewhere in their family and they decide to take a leave of absence from practice or decide to leave it altogether. There's any number of other reasons, a natural disaster, perhaps there's a fire in the office. Any number of reasons might cause a person to have to close down their practice, whether it's for a short or long period of time. And having this information handy is going to be useful in all those situations.
Right.
I agree with you 100% on that. I can't tell you the number of situations I've had where somebody has to go in for surgery, they're going to be away from their practice for a while. It's a real pain in the neck if they don't set up this kind of thing in advance and think about it.
Right. That makes a lot of sense. So there's a lot of things that can happen. And what's kind of interesting is of course, I got to tie it into our usual stream, but like talking about risk analysis and preparedness for security situations, certainly people who have attended my webinars or other trainings, I always talk to them about what security is. And we emphasize the security of the information, meaning the information is safe, it's intact, and it's confidential. Like we emphasize confidentiality so heavily, Rob and I, in everything we do, because it's the big issue. But what you guys are talking about is also security. It's just not information security. Well, it is information security, but not in the sense of confidentiality of the information. It's the security of the integrity of the information and the availability of the information, both of which are also principles that HIPAA requires us to protect. I mean, effectively, this emergency plan is not just your ethical legal obligation to your clients in the sense that there's regulations, there's ethics codes that say you need to have an emergency plan. This is also making sure the information is available when it's needed and making sure the information doesn't get lost or destroyed, which are also principles of security that HIPAA requires us to do. So it's a nice way to, I know I like to tie everything in. It's one of my things, but I really do think this ties in. I mean, this is all part of the general planning process for ensuring the security of your practice. Rob, you're smiling when I talk about this, so I assume you have similar thoughts.
Yeah, you're exactly correct, and these are the kinds of steps that, we talk about therapists kind of sticking their heads in the sand about the concept of, if I die or retire, what am I going to have to worry? Oh, that's a long ways off. But they also sometimes stick their head in the sand about these security measures and the HIPAA risk analysis and so forth. And I know you've seen the same. But a lot of these things are tied in together, and being able to address them is really important.
So I realized something additional to this. Sorry to jump in there, but like when I do risk analysis consulting with people, and Rob does that as well, everybody. We're talking about the typical HIPAA checklists. We're going through that stuff to make sure you have information security. And so often we'll be talking about ways that I can like obscure information so that it becomes, the confidentiality of it is protected. And it occurs to me I've got another thing to add into my analysis here, which is, okay, so we're obscuring this information in order to protect its privacy, its confidentiality. But how are we going to make sure that your emergency response team can still access it? How are we going to obscure this against the bad guys, but make sure the good guys can still access it? I realize this is something I need to add to my risk analysis.
All right. Well, and just having a backup plan for yourself. What if you forget how you coded the information?
That doesn't happen, Rob.
I've dealt with aging doctors and mental health professionals, the one who ended up with Alzheimer's. And we kind of rely on our own little systems and to try to explain it to somebody else. If that's not documented somewhere, it really could end up harming the patients and the clients.
Yeah, for sure. And I think you guys you're also pointing to something. I'm sorry to get into my little pedagogy here, but definitely a big part of my big mission and message is I always want people to recognize that the procedures and policies that you have in place are just as important as the technical stuff you have in place. Technical being like passwords and encryption and all that stuff that people tend to come to Rob and I for. We don't really think about how the policies that you follow are just as important as those technical things you do. So, for example, Nancy was talking about, like, if there isn't some way to reference what your little encoded way of writing about things means, like if I can't go look up what this client's initials stand for example, then I'm in trouble. I can't contact that person. I can't find out what's going on with them if I'm on the emergency team, or if I'm the doctor who's coming into dementia or something along those lines, like Nancy was just talking about. So your policies and procedures would be vital there, because you'd probably have a procedure that says, I have a sheet somewhere, a master sheet that defines, okay, if I identify my clients by their initials, I have a sheet that defines who those initials stand for, right? And so one of my procedures would be that anytime I add a new client, I add them to this sheet. You know, I make sure that my system has some kind of reference, and I keep that reference secure. I keep it in my file cabinet or in my electronic record system or something like that. So like that's an example where following your own procedures is an essential piece of making sure your security is in place. So that's my little.
That's a really good point. I think a lot of counselors and mental health professionals are aware that they need to be careful about privacy. They use the HIPAA notice of privacy practices, but I know as a fact, after talking to a lot of people, that they don't have policies and procedures in place.
Right, right. And so what I'm really realizing is that you guys are talking about the preparedness for post-retirement or death or illness or something. You're talking about that preparedness. This is another aspect of the policies and procedures for the practice. I mean, I would almost put them all in the same manual along with your HIPAA policies and procedures. I mean, I would. Not everyone would.
Maybe it's something that should be cross-referenced with that.
Ah, that makes a lot of sense. Right. Okay. So we're at 11 o'clock. Do you guys have anything else that you want to mention? Anything that didn't get said here?
Nancy, I'll let you go first.
I think the main thing is that all healthcare professionals really need to get their heads out of the sand. And even if it's, you set aside a certain week that you're going to do this, or you say, I can't do that, I'm going to set aside every Friday afternoon at 4 o'clock for an hour to work on this. Whatever it is, whatever works for you, do it. I mean, really pay attention to this issue and learn what you can and do it.
Right on.
Yeah, I just want to underline and reemphasize that we not only have an ethical imperative to do this, and if you look at our website at privatepracticepreparedness.com, we actually list the ethical codes for the many different mental health and medical disciplines, and they all. Hey,
Rob, would you spell that out for them, because it's a little hard to hear it?
Well, it's
the website.
I bet what we can do is add a link to the show after we post it.
Yeah, that's what we'll do.
It's privatepracticepreparedness.com. But all of these mental health and medical associations, the Code of Ethics refers to needing to have a plan like this in place. And it's not just about meeting that ethical imperative, but as you've said so eloquently, Roy, also taking care of the security and privacy of information, and making sure that your clients are taken care of and there's continuity of care, even if you're not in the picture anymore.
Yeah, right on. Well said, guys. Thanks, Nancy, so much for coming on. We're sorry that Google failed us all in managing to get you on the actual Hangout, but it looks like our emergency backup plan worked.
Did something to, probably because it's me putting it on, but you know, it does say something. It does say that you got to have that backup plan.
Yep.
And being with you both today.
Yep, right on. Thanks for coming. And yeah, and thanks everyone for joining us. We had an average of about 10 people watching at different times, but as everyone knows, this show is available forever and ever. Amen. Just go to our YouTube channel. And we will have a link to the privatepracticepreparedness.com website in the YouTube channel and also on the event page that you have probably went to register for this. Either way, you can find that. We'll probably have links to a few other resources as well, I'm sure, Rob. I don't know. We'll come up with some to put there. And we'll see you guys at the next show.
Thank you, Roy.
Thanks, Rob. Thanks, Nancy.
Thank you, Nancy.